Our next speaker, okay, I'm going to start just a second. Cameras ready? Our next speaker comes to us from Denver, Colorado. This gentleman is a constitutional freedom attorney who I had the pleasure of meeting many years ago at the annual conference of a group called the Fully Informed Jury Association. He's a legal scholar of the best kind because he stands for freedom issues and litigates issues that no one else wants to do. Issues like freedom of speech, he defends. He defends jurors' rights. Of course, he has to take normal cases like everybody else to make a living as well, like the rest of us do. But he does dedicate a large part of what he does to doing freedom litigation, to expand freedom from all of us, because he really cares. And he has a lot of good information to share with you today about the importance of jurors' rights and powers to restore our freedoms, how they're under attack, and an invitation with you to support us, to defend the jury as an institution, to protect your rights and your liberties. Please help me give a warm hand of welcome to Mr. Paul Grant.
Thank you, Payman. It's good to be here. I haven't seen Payman in a number of years, and I don't think I've seen many of you ever. But I want to talk to you a little bit about the history of the jury and then tell you about where the jury is today, at least as far as some of the things that I've seen in my legal practice and in just my living in this country. Some 370 years ago, I'm not going to go back to the beginning of time to talk about the jury, but I'm going to go back, way back in time, say to about 370 years ago. Back in England, there was a man named John Lilburn. I don't know if many of you know the history of John Lilburn. He was also known in history as Freeborn John. John was arrested in about 370 years ago for handing out illegal religious literature in London. And John was brought to trial before the Star Chamber, which was something which came before the jury, or after the jury, or at least at some period of time in England's history. The Star Chamber was a trial where the king's ministers were the jury for a citizen charged with crimes against the crown in England. And John Lilburn was brought to trial, and they said, John, you have to answer our questions. He said, no, I am an Englishman, I have rights. And this was a novel concept at the time. And John Lilburn said, I won't answer your questions because I have the right to remain silent. And they said, well, John, no, you don't have the right to remain silent. He says, I also have the right to counsel. They said, we'll be your counsel. No, you can't be my counsel. I want my own counsel. And they said, well, John, we're going to try you and decide your fate. And he said, no, I demand trial by my peers. I demand trial by a jury of my peers. And they said, no, John, we are your peers, at least as far as this proceeding is concerned. And they condemned John Lilburn, but not anything harsh. They convicted him and sentenced him to public humiliation, to be displayed in the stocks or whatever they call those things, where you stand in a public square and you're humiliated. People can come by and throw things at you or jeer at you or whatever. And as John Lilburn was standing in those stocks being humiliated in London, he reached into his pocket and pulled out of his pocket the same religious pamphlets that he'd been convicted of distributing. And he threw them to the crowd. And needless to say, the English authorities were not too pleased with John. And they took him down from there and said, well, John, you know, you've violated our trust, and now you're going to prison. So they put him in prison. And while in prison, John started drafting petitions to demand the rights for Englishmen, and English women, by the way. And eventually he was freed from prison, and he continued his activist ways. And he became a very important figure historically, even though he's been mostly lost in time, lost historically to the English, and to the Americans as well. He was known by our founders, but he's forgotten today. Lilburn was tried for treason on more than one occasion. On one occasion, he was brought into an English courtroom in the Old Bailey, the most famous court in England. And he was tried by a panel of judges, but also by a jury. At that time, they did have a recognition that he had a right to a jury trial before he could be condemned to death. And John Lilburn, when tried, told the judges that he didn't answer to them, that they could not judge him, that he would be judged by his peers, and he told the jurors to ignore the judges. And the judges were quite upset with John, but the jurors did their duty and found John Lilburn not guilty of treason, despite the instructions from the judges that they should take the law from the judges. And as most of you probably know, in this country today, every judge who instructs a jury says you must take the law from me. You can't judge the law for yourselves. You can't take the law into your own hands. You must follow my instructions on the law. And if you're not willing to do that, you need to get out of here. You can't be a juror in America today, at least any place that I've practiced or heard about, unless you agree, at least quietly, at least implicitly, to go along with the judge. If the judge misdirects you on the law, that's too bad. If the judge advises you what the Constitution is and you think he's got it wrong, you have a duty to disqualify yourself, not the judge. Now, I don't know how that works. I thought judges had sworn to uphold the Constitution, but instead, jurors have sworn to uphold the judges. Now, I don't know how that works, where that came about, but I do want to talk about a couple of cases to give you some examples of what goes on if you are an independent-minded juror. Because each of you, maybe not each of you, some of you probably are not on the rolls and will not be selected for jury duty. For one reason or another. Now, they may have decided that based on your politics, you shouldn't be on the rolls. Or maybe you don't do something that gets you on the rolls. But whatever. But in Colorado a few years ago, a lady named Laura Creho was called for jury duty. And during jury selection, they asked her a few questions, and she answered basically. Like you might, yeah, I can go along with all this this process. She didn't think about too much about what they were asking her to commit to. It's a drug case, and when Creho was selected for the jury, she deliberated like a responsible juror. And when she got to the jury room, she told the others she wasn't convinced the defendant was guilty, and they said, "Well, we're convinced she's guilty." And Laura Creho also told them, "And by the way, I don't think this is what we should be doing to a person. Even if she did have a drug problem, even if she was guilty, I wouldn't be in favor of this process because I think it's wrong. I think it should be decided in a different way." And they said, "Oh, you can't talk like that. The judge told us we have to do it the judge's way. We can't talk about things like that." And she said, "Well, we don't have to listen to the judge when he tells us how to speak in the jury room or how to think. We have rights. We are jurors. We can judge a lot more than the judge tells us." "Oh, no, you can't say that either. That's illegal." And she said, "No, it's not illegal. It's the right of jurors. It's the right of jurors to vote their conscience to decide whether there's justice in a conviction or not." And they said, "Oh, you violated your oath. You have now really broken the law, and we have to do something about you." So they sent a note out to the judge saying, "Judge, can we get rid of this juror? She's obviously, not the right kind of person." And the judge got the note, and the judge called the jurors out and got really upset. Somebody here is breaking the rules. Of course, he was the one who broke the rules. But they decided that they had to end that trial right then and there and investigate what went wrong in the jury selection process. They never thought to look at the judge to see what went wrong in the jury selection process. The lies that the judge told to the jurors about what their duties were, what their legal rights were, and what they must do or must not do. The case of Laura Creho became a nationally important case in the late 90s. And she was convicted. She was put on trial for contempt of court, charged with contempt for not telling the judge during jury selection the answers to questions the judge never asked. And they wanted Laura Creho to disclose during jury selection that she understood the rights of jurors. She understood the concept of jury nullification. In fact, she had the temerity when she was in the jury room. She didn't show this at the time, but she had a FIJA brochure, a Fully Informed Jury Association brochure, in her pocket. When the trial was over and a mistrial had been declared, she went to one of her co-jurors and said, "I was trying to explain to you what's in this brochure. Here, look at this." Well, that juror took this brochure and turned it into the judge. This was evidence in a criminal trial. Evidence of crime, alleged crime committed by a juror advocating jury rights to a jury. you need to understand, for any of you who ever are called for jury duty, that you have, what the legal system would say, you have no First Amendment rights, or almost no First Amendment rights as a juror. It used to be believed that what was said in the jury room stayed in the jury room, that it was confidential, that it was privileged, or whatever. But that isn't true. And you who live here in California may be aware that under California law, right now they look for non-deliberating jurors, those that won't go along with the rest of the crowd. So if you are a dissenting juror in California, for instance, you can be removed from jury service if your co-jurors accuse you of not deliberating properly. So if you have the wrong thought processes and express them, or don't express your thought processes, or just don't go along with the majority in California now, you can be removed, and the California Supreme Court has said that's constitutional. The U.S. Supreme Court hasn't weighed in on it. So what I'm talking about a little bit today is, I guess, sort of a guide and maybe a little practical suggestion about some things you can do if you were called for jury duty. Laura Carrijo was eventually convicted of contempt of court by a judge. She was denied a jury trial because they recognized that a jury probably wouldn't convict another juror. And so they employed this rule that under contempt prosecutions, if you limit the punishment to 6 months or less, a person is denied a constitutional right to a jury trial. So a judge decided the case against Laura Carrijo, and after hearing the evidence against Laura Carrijo, the judge said he would take the case under advisement. And I wanted to say to the judge, if you can't make up your mind, Judge, can we declare a hung judge, please? Have a new trial, find another judge who maybe can decide the case. But the judge decided the case eventually after he had someone else write the opinion for him. It took the judge 3 months to decide whether Laura Carrijo was guilty or not of contempt of court. And I thought there should have been a time limit. I mean, they don't let jurors deliberate for 3 months, but judges apparently are different. And anyway, the judge came out with a very carefully written opinion, which he got from somewhere. I haven't yet found out where. And tried to justify prosecuting and punishing a juror for a refusal to answer or failure to answer questions which were never asked. Laura Carrijo was, under this theory, supposed to have confessed during jury selection that she didn't like the drug laws, but nobody ever asked her if she liked the drug laws. Laura Carrijo was supposed to have confessed to the judge during jury selection that she understood the historical power and rights of the juries to judge the laws. They asked her the questions about whether she understood those rights and duties and powers of jurors. So all the things the judge would have wanted to know so he could have kept her off the jury are those things which the law said she was obligated to answer. The law, at least, is spoken by that one judge. And Laura Carrijo was convicted and not sentenced to jail. Court TV was in the courtroom on the day of sentencing, and the judge decided to send a very powerful message to Laura Carrijo and anybody else who was thinking that they had rights as an independent juror. They wanted to send a strong message that you can be prosecuted and punished as a juror if you're caught thinking for yourself in the jury room and disrupting the conviction process. The trial. And Laura Carrijo was the sole holdout against conviction in that case, by the way. And I've yet to see a case where they've prosecuted a lone holdout for conviction. They only prosecute those who hold out for acquittal. I don't understand the logic of that. It doesn't seem like it's fair, but they only go after the jurors who vote against conviction. Well, the Colorado Courts of Appeal decided that there was something wrong with the process, but they didn't want to reach the issues of jury rights, jury nullification, jury power, jury clemency, jury mercy, all the things that you might say that describe the power of a jury to bring back a verdict of not guilty, without question, or even an individual juror to hold that position. The Colorado Courts of Appeal did what most other courts have done. They ducked the issues. They decided that they couldn't discuss jury rights because it was just too dangerous a topic. What they decided instead was, on a narrow issue, to decide that the evidence against Carrijo should not have been admitted if it came out of jury deliberations, that the jury's deliberations should be kept off limits. If the government could prosecute Carrijo based on what she did or said outside the jury room, they could prosecute her. But because what they had used against her was evidence from what she said in the jury room, the prosecution had to be thrown out, and the conviction had to be thrown out. And they gave the district attorney a second choice, a choice of whether to try her again. And the district attorney had been sort of publicly humiliated for the 2 or 3 years the case had been going on. The public opinion was really in favor of Creho. And the district attorney decided he wanted to know more of the case and decided to dismiss in the interest of justice, as he described it. Of course, that wasn't the interest of justice. The reason for prosecuting a juror is to send a message to the public that if you come into the jury room, you too can be prosecuted if you don't do it the way you're told you're supposed to do it. Now, this is a phenomenon which only occurs maybe once every 10 or 20 years, at least as far as I can see. And it happens in different states. It happens around the country. Sometimes it doesn't reach the light of day because the person who's charged doesn't know enough to find one of the few attorneys who might defend their rights, and it never becomes public. Laura Creho, had she not found an attorney willing to raise the jury rights issue, might have been convicted. In fact, she did find a lawyer that would help her. The American Civil Liberties Union agreed to represent Laura Creho. They provided an attorney and recommended that she plead guilty to contempt of court. And Laura didn't think that was much, exactly the route she wanted to go, so she turned down their offer of free legal services and instead decided that she would hire a private attorney who didn't believe that she'd done anything wrong. I had the good fortune to be contacted by Laura Creho at that time and represent her throughout the proceedings. And I advise you that if you ever find yourselves in a similar situation, the best defense, and I think Paymon's a little bit wrong, I don't really defend the rights of jurors, I promote them. I don't go backwards, I go forwards, and I think the reason that Laura Creho ultimately won her case was that she attacked the legal system that was attacking her. She counterattacked, and she counterattacked with publicity, she counterattacked with an aggressive legal strategy, and she counterattacked it by promoting herself, say, to Court TV. And the more daylight that was shown on what was being done to Laura Creho, the more that the powers that be in the legal system retreated, the more they ran for cover. And I think if any of you ever find yourself in a situation where you're confronted with a challenge like that as a juror, then I think the best defense is a very strong and aggressive offense. There's been a more recent case of a similar thing that's happened. The case out of Idaho, a lady named Carol Asher. She was charged with perjury. She was a juror in a criminal case, another drug case. This was up in Grangeville, Idaho County, Idaho. And Miss Asher, this was just last year, Miss Asher was selected for jury duty, and once in the jury room, she said, I don't agree with the judge. And they said, what are you talking about? She said, well, he said the search of that defendant's car was illegal. It was legal. I don't think so. She said, I think people have Fourth Amendment rights. I think the judge is wrong. It was an illegal search. And the other jurors told her, you can't talk about that. And why not? Well, the judge told us we can't think about that. Well, who does the judge think he is? He can't tell me how to think. He can't tell me how to vote. She said, I answer to a higher power. I don't answer to the judge. And the other juror said, oh my God, you should have said that. You should have told them that. You wouldn't be in here today. And you've committed perjury. You've lied to the judge. She said, I don't know what you're talking about. She said, I just wanted to be on this jury to speak my piece and do my duties. And they said, no, that's a lie. That's a crime. So it happened again in Idaho, and it just happened a few months ago. Carol Asher was charged with a crime of perjury for not telling the judge what her views were before she'd heard the case. And the Idaho district attorney prosecuted her, decided that since he was a witness, he couldn't prosecute her, so they brought in the attorney general to prosecute Carol Asher. And she was facing 1 to 14 years in a state prison. And she hired a local attorney, and the local attorney also brought me into the case, and we obtained the transcripts. And what she was charged with lying about, Carol Asher, during jury selection, wasn't in the transcripts. And I wasn't exactly sure what it was that she did illegal. I'd been through the Creho case, and I realized Creho committed contempt by not answering questions she wasn't asked. So I wasn't sure what the theory was against Carol Asher, but then I heard it from the Attorney General. He wrote a brief on it, a legal brief. He explained it. Carol Asher remained silent during jury selection, and for that, she's charged with a crime of perjury. And they weren't kidding, and they used some very creative legal writing and legal thinking to justify that, and you might understand where they got their legal theories. They got them from California. In Idaho, they cite to a lot of California law, case law, a lot of opinions out of California courts, and they found one They found a California Court of Appeals decision where the California Court of Appeals said silence can be a false statement. And it can constitute the crime of perjury. Now, you know, and he was serious. The Attorney General of Idaho was serious in prosecuting Carol Asher. And they said that when you're asked a question, you're a juror sitting in the jury box, or a prospective juror sitting in the jury box, and the question is asked, can you be fair and impartial? If you don't answer no, and later in the jury room you tell the other jurors you've considered the illegality of a search or some other improper reason, they can now charge you for perjury for not having disclosed in advance that you can't be fair and impartial and follow the judge's instructions. Because if you decided in the jury room that you're not going to follow the judge's instructions, then you obviously should have told them that beforehand. Even before you heard the case and even before you knew what the judge's instructions were, you're asked, can you follow my instructions on the law? And if you say yes, then you have to do it, no matter what those instructions turn out to be. And if you don't, then you can be charged with perjury and you can be prosecuted, or you can be charged with contempt of court and prosecuted. They're not just removing jurors from the jury room, as in California, but they're prosecuting jurors occasionally. So if you're called for jury service and you do understand the juries have a right and a duty to exercise their conscience and do justice, and you do that, there may be consequences. People ask me all the time, well, what should I do if I'm called for jury duty? Should I answer the judge's questions honestly? Should I volunteer information? Should I wait till they ask me specific questions? What should I do? And all I can say is that you should follow your conscience. If you believe that the judge is going to be upholding the Constitution and you're called for jury duty, if you want to give him the benefit of the doubt, or her, then do so. And if in their instructions they then tell you to violate the Constitution, I don't think you're breaking a promise to follow the instructions of somebody you thought would advise you properly. I think if they told you that what the Constitution was is, that there is no Second Amendment, for instance, then they're lying to you. I think you no longer have the obligation to follow a promise made to somebody who's lied to you to get you there. But once in a while, a juror speaks up during jury selection, and the judge says, can you follow my instructions on the law even if you disagree with them? Well, I hope so, Judge. What? What did you say? You question me? How can you say that? What do you mean you hope so? Well, in numerous cases, I've read transcripts where jurors said something like that. Judge, I think I can follow your instructions, but it depends. Well, what do you mean it depends? Well, it depends on whether you instruct me properly on the law or whether you don't. Well, that's contempt right there. I mean, you as a citizen can't talk to a judge that way. I mean, you'll hear about other people and judges. The judges are they the law? Are they above the law? I can't what position they sit in, but maybe they think they are the law. But if you question a judge, judges go nuts. I had an airline pilot once in a gun case, a case that involved the use of a gun, asked the question, can you follow my instructions on the law? And the juror said, well, as long as you don't tell me there is no Second Amendment. And the judge said, you can't sit in this jury. Get out of here. Basically, that was it. It was over. It was done. That juror was out. And I handled an appeal one time of a case where a judge asked the jurors, can you follow my instructions? And the guy said, it depends. And the judge, federal judge, Richard Maitch from Denver, who presided over the Oklahoma City bombing trial, among other things, Maitch said to this trial juror, what do you mean it depends? Well, Judge, I try to follow your instructions, but if there's a real powerful issue in this case, the issue of conscience, where I have to rely on my conscience and go against your instructions, that case could occur. I don't know that it'll be in this case, but it could occur. The judge says, that's not the law. And the juror said, yes, it is. And the judge said, well, who are you? He said, well, I taught law for 25 years, and that's the law. And Judge Maitch says, no, it isn't the law. Basically said, I'm the law. And the judge had told him, well, it's your duty. And the juror said, no, it's my inclination to follow your instructions, but the jury always has the power to acquit, notwithstanding the evidence. And the judge kicked him off the jury and then told the jury, the remaining jurors, that this juror was wrong, that his statements were misstatements of the law, and he told the jurors they could only acquit if the government failed to prove its case, which is a total lie. A total lie. They can acquit for any reason whatsoever, and the reasons can't be questioned. That's the law. And the judge basically told the jurors that they could only acquit if they found reasonable doubt. Now they shifted the burden. Now somebody has to prove reasonable doubt instead of the government having to prove its case. And now the jurors have to justify an acquittal and have to offer reasons for an acquittal rather than the government having to prove its case. Well, the 10th Circuit, the Federal Circuit for the 10th Circuit Court of Appeals, didn't have any interest in the legal arguments there, as courts never do. That juror was removed, that defendant was convicted, and he was sent to prison. And that happens every day in trials around the country, in cases around the country. If you are ever selected to jury duty in California, those of you who are from California, or for wherever you're from, and something arises in the jury room, and you find yourself wanting to educate the other jurors about jury rights, you may find yourself exposing yourself to a criminal prosecution. So you have to decide for yourselves whether you really want to do that, and or whether you want to speak up during jury selection and make sure they know that you understand jury rights so you'll never get in a jury. I think it is a matter of individual conscience, but it has a lot of risk if you're selected for jury duty. But the founders of this country thought jury duty was important, and when the English started taking the right of jury trial away from Americans, it became one of our grievances. It was one of those grievances that was listed in the full-length version of the Declaration of Independence, not the short form that Paymon read with you earlier. But it is one of the grievances that England was depriving us of trial by jury. And England was doing that precisely because American juries were exercising their powers to acquit Americans accused of violating English laws, which the Americans realized were no laws. They were no laws for a number of reasons. Number one is the Americans had no right in the creation of those laws. There were laws where they weren't represented. But number two was that the laws of England violated the rights of men. It violated individual rights and individual liberties, natural rights. So Americans knew that they could judge for themselves the validity of the law. They knew that, and they insisted on that, and they exercised that in the jury room. The United States Supreme Court recognizes that history, and they know that that history was what was involved with and what was embedded in our right of trial by jury in this country. They've never denied it. They've said it's not an abuse of discretion to hide the truth from the jury. That's what the Supreme Court said in 1895 in a case of Sparf and Hansen versus the United States. The defendant wanted to inform the jury of their rights to judge the law and the fact and to bring back a verdict of acquittal despite the facts and the law if they thought that was just. The judge decided not to instruct the jury on that historical power, and the U.S. Supreme Court spent a lot of pages and thousands of hours of research tracing the history of the jury in that case and deciding that, yes, that was a powerful and important part of American history, but it's not wrong for the judge to hide it from the jury. And ever since then, that's been basically the role. Courts either hide the truth from the jurors or they affirmatively lie to the jurors about their rights and their duties. But the U.S. Supreme Court is still aware of that history and has acknowledged it as recently as 1999 in a case of, I think it's Jones versus the United States, where they traced again the history of the jury, and they found that Americans were fighting over the rights of the jurors to bring back acquittals regardless of the law and regardless of the evidence, and that fight for the power and the rights and the responsibilities of jurors had to have been on the minds of the framers when they adopted the guarantee of the right to trial by jury. That's what our own U.S. Supreme Court said as recently as 1999. In fact, they quoted with approval from Blackstone, this great English commentator on legal history, and they said that this history of the jury's power to bring back verdicts of acquittal despite the facts and the law was an unreviewable power, and Blackstone called it pious perjury when a jury would bring back a verdict of acquittal when they thought the punishment would be unjust, when they thought the law was unjust or invalid, or for whatever reason, the jury decided to bring back either a verdict of acquittal or a verdict of conviction on a lesser charge. That was within the power of the jury. When the U.S. Supreme Court has recognized that that is the part of the definition of the Sixth Amendment guarantee of a right to jury trial. So I started off with the history of John Lilburn, Freeborn John, because it's a history that's been lost to us, but it wasn't lost on the framers of our Constitution and the founders of our nation. In fact, one of Thomas Jefferson's nephews was named Lilburn, after John Lilburn. John Lilburn was a wonderfully important historical figure who's been erased by English historians and never even made it to American history for the most part. But if you go on the web sometime, look for John Lilburn, Lilburne, you'll find some interesting history there. And I think it's really worth noting because he advocated a lot of other rights. He advocated an end of tithing, compulsory tithing to the Church of England. He advocated the end of cruel and unusual punishment, the right to jury trial, the right to lawyer, the right to remain silent. And he did all these things about 100 years before we had an American Bill of Rights. He gets no credit here in this country. He gets no credit in England. I've talked to English lawyers who've never heard about John Lilburn. And he's been erased from time and accused of actually having been a socialist. His group are called the Levelers, Levellers, because they wanted to do away with special privileges for rich fat cats who were getting special corporate privileges from England, from the king. He was accused of being a socialist, but he didn't want to redistribute wealth and property. He wanted people to have a right to make it for their own. And those of you who are familiar with initiatives and referendum, he started circulating petitions and presenting petitions to Parliament demanding rights of Englishmen. And they said, "Who the heck are you? We represent Englishmen, not you." And they put him on trial for treason for submitting petitions to the government, asking for changes in the politics. He also was the person who formed a group which was called the Agitators. If you want to hear about political agitators, the word came from John Lilburn's people. And these were people he was organizing in the English army of the 1600s. He was organizing resistance in the military to teach English soldiers that they had rights too. He advocated the rights of women. He advocated a Bill of Rights, and he's a person who needs to be rediscovered historically. But concerning jury rights, I don't think there's anything more important today in the American criminal justice system than the power and the rights and the continuing vitality of the jury system. You know, on the one hand, it's horrible what the courts are trying to do to destroy and to diminish the jury system and to intimidate jurors and to chase away jurors who know how to think for themselves and understand the jury's rights. But on the other hand, this has been a battle since there ever were juries. It's always been the same way. Judges have always tried to suppress juries. It's a matter of power of the judge versus the power of the people. It's going to be an ongoing battle. And if you ever do have a choice to be involved in a criminal trial as a juror, I say do it if you can. And of course, if you're ever in a criminal trial as a defendant, you certainly better rely on the jury. And the jury system is the best of all, the best thing we have going for us in the criminal justice system. And so do your part to support it, to participate in it, and to fight for it. Thank you. Amen.
Thank you very much, Paul, for that very enlightening presentation. Folks, I want to remind you, if you want to hear the banquet speaker tonight, the Joe Bannister, we have about 20 tickets still available. You can get it at the luncheon. And the luncheon with Ryan Fowler is downstairs at the hotel bar. You go to the lobby, make a right turn, and the bar's on your right-hand side. And the hotel restaurant is near that same corner of the restaurant also. Before I bring the next speaker, I want to make an announcement that Chuck Conscious asked me to let you guys know he has a meeting with his group at 1 o'clock. It starts in the middle of a lunch, and it's going to be downstairs at the restaurant. In the lobby of the hotel. So if you belong to Chuck Conscious' group or you want to meet with them at 1 o'clock in the afternoon today and tomorrow, they'll have meetings going on. Our next speaker is also going to talk about juries, but a little different kind of jury with a little bit of a different kind of a solution. He has a proposal on how to handle the judges who seem to continually insist on breaking the law and the Constitution and our rights and jurors' rights and jurors' powers to, aggregate the powers of themselves and the forces behind them. And I like this proposal. This gentleman, I've known him for a long time, and as we'll tell you, he was a fully informed jury association activist first for many years, and still our fully informed jury association brochures are printed by him. And I'd like you to pay close attention to this initiative that is right now on the ballot in North Dakota and the Dakotas. And let's give a warm hand of welcome to our speaker, the chairman of the Jail for Judges, the jailer-in-chief, Mr. Ron Branson.
As he says, my name's Ron Branson. I'm the Commander-in-Chief of the National Jail. We're in all 50 states. And I want to give maximum time to our gentleman here from South Dakota. He is the one who has led this cause and got Jail for Judges on the ballot in South Dakota, and the people of South Dakota are going to be voting on it this November the 7th. And we got the government up in arms, really. Bill, come on.
Thank you, Ron. I've been working on improving my public speaking skills, and I think I've made quite a bit of progress, except I still can't remember anything. And I apologize for that. Most of you are already familiar with the national organization commonly known as JAIL. For those not familiar, it stands for Judicial Accountability Initiative Law. We have in our great country many problems, some of which continue to worsen, and some of which and some of which we are making progress towards solving. We've already heard several problems that we face as a country by other speakers, and we've got another day and a half to hear quite a few more, I'm sure. I want to talk about one of the problems that we are making progress towards solving. And that problem, in my opinion, is the largest problem our nation and our very freedom faces. I'm talking about the problem of judicial unaccountability. Our founding fathers went to great lengths to ensure that our government servants, including judges, would always be accountable to their masters, we the people. But they also knew for this accountability to continue to exist, it would require constant vigilance by the people. Today, it is clearly evident that the masters, while dozing off, allowed the servants to take control of the house. And what servants were our founding fathers most afraid would take over the house? It was the judges. Let's fast forward to today. Instead of judges being the servants of the people, they are now the masters, even referred to as little Napoleons, thugs in black robes, and gods of the courtroom. Thus, the problem. And now the solution. To establish a mechanism whereby the people are once again the masters and the judges the servants. A journey of 1,000 miles begins with one step. Ron Branson took that first step and founded JAIL. It now has chapters in all 50 states. I am the chairman of the South Dakota chapter. And please keep in mind, JAIL's sole purpose is to restore to the people. And while progress is being made with the increasing membership of JAIL, nowhere is the progress as fast-paced as in the state of South Dakota right now. This past summer and fall, we collected over 46,000 signatures from registered South Dakota voters. We submitted the signatures to the state of South Dakota, who, after counting the signatures, found that we had turned in 7,000 more signatures than was required. South Dakota now has the honor of being the first state in the Union to put meaningful judicial accountability legislation on the ballot for the citizens to vote on. It's called Amendment E to the South Dakota Constitution. The election in South Dakota this coming November will be the pivot point. Will the voters of South Dakota decide to accelerate that journey of 1,000 miles and vote in favor of judicial accountability? Or will they let South Dakota, and in fact the entire nation, continue to slip toward total judicial tyranny? We need your help. The opposition is formidable. They have so much to lose if we prevail next November. In fact, they have their entire corrupt way of life to lose. You see, judicial accountability returns the control of our courts, and by extension, all government, back to the people. The opposition has already come out strong against the South Dakota Amendment E. Not with any reasonable objections to the idea of holding judges accountable for misconduct, because there aren't any reasonable objections, but instead with lies. Lies are the opposition's only ally. Truth is ours. With the truth on our side, and with your help to spread the truth, we will win in South Dakota. And we must win in South Dakota for the sake of the entire nation. Please visit our booth, Jail for Judges. Also, please visit the South Dakota Amendment E website, which is www.southdakota.judicialaccountability.org. And please consider a donation, which you can do at the website. Again, that's southdakota.judicialaccountability.org. Thank you.
We have a donation box out there in front of our table. If you would stop by and contribute $100, $20, whatever you might have to help, because believe me, the future of this country lays heavily upon our cause in South Dakota. Now I want to introduce to you our Lieutenant Commander-in-Chief, my second in command, Attorney Gary Zerman.
Thank you, Ron. Thank you, Bill. I want to thank everybody for coming here today, because the only way we're going to defeat this and succeed what's happening with our government today is by becoming aware, then becoming educated, and then becoming empowered. The Declaration of Independence is so important. Why? Because that document said that our rights don't come from the king. They don't come from the government. They come from our Creator. Because if they come from the king or from the government, they can just as easily take them away from us. And so the Declaration of Independence, that was the promise. And the fulfillment of that promise was our Constitution. And it starts out with, we the people. It's not we the government. It's not we the judges. Now I'm here to give a little speech about the doctrine of absolute judicial immunity. Raise your hand if you know what that is. Well, most citizens don't know what it is, and that includes attorneys. I didn't know about it after going through law school. In fact, my legal education was totally remiss. After I learned about it, I went back and looked at my constitutional law book, which was Gunther on Constitutional Law, the 10th edition. And it was used by many, many law schools and many, many generations of law students. And I went to the topical index in the back. I looked for immunity, wasn't there. I looked for judicial immunity, it wasn't there. Then in the front of the book, it had an index of cases. By then, I was familiar with all the cases dealing with the doctrine of absolute judicial immunity. I serially went through there, and guess what? Not one of the cases was in there. Well, the doctrine of absolute judicial immunity comes from an 1872 case authored by Justice Field, who was appointed to the U.S. Supreme Court by Abraham Lincoln in 1863. Earlier, he had been an associate justice of the California Supreme Court, and in fact, the Chief Justice. Back then, the court had 3 justices, a chief and 2 associate justices. Justice Field wrote that opinion, and it has no constitutional basis in it. He cites to no place in the Constitution where the doctrine of absolute judicial immunity comes from. And what this doctrine does is, as long as a judge has jurisdiction and does a judicial act, it's a complete bar to sue that judge. And it includes malicious and corrupt acts, including a judge could fix a murder trial, and you would have no civil remedy against the judge. Now, that is a direct attack on the sovereignty of the people. It's inverting our sovereignty. It's placing the government, and here the judiciary, over, above, and beyond the people. Now, how can that happen? All of those constitutional decisions, starting with Bradley versus Fisher, that's the 1872 seminal case. Then it goes to Pearson versus Ray, Pulliam versus Allen, Stum versus Sparkman, Morales versus Waco. That takes us up into, I believe it's the early 90s. Not one of those cases cites the Constitution. And you know why? Because it isn't there. Look at Article 3, it deals with the judiciary. It says nothing about immunity. In fact, the only privilege or immunity in the Constitution for the government is the speech and debate clause for Congress. Anything else regarding privileges or immunities, those are given to the people. Now, what's also astounding is how can judges give judges absolute immunity? I thought there was something called the doctrine of checks and balances. Separation of powers. What happened when judges went out there and unilaterally grabbed immunity for themselves? Where was the executive branch? I'm still studying that. I haven't found anything yet. Where was Congress? Now, why is that important? Because let's fast forward to today. I believe some of you have probably heard of a recent case called Kelo versus City of New London. And that's, for the people that don't know, that's the eminent domain case, where in a 5-4 decision authored by Justice Stevens, they trashed the public use clause of the Fifth Amendment, that you can condemn someone's property under eminent domain, take it from one private person. Up to that point, only government could do that for a government use. And even with that public use clause in there, there have been problems where developers will go to the building department, the zoning department, and cut a deal and take somebody's property. One example is Dodger Stadium. That used to be a community. Is a baseball team a public use? But now they've got a green light to take private property, not for public use, but to give it to another private entity if it's going to increase revenue. So that's why it's important. How does the power come back to we the people? Again, it starts out, we the people, we are the tree trunks, we are the roots, and we loan the power to government, the three branches. Government gets its just powers from the consent of the governed. But the fact of the matter is, power has to be watched. It has to be reported on. It has to be held accountable. Because as soon as government gets power, it wants more of it. And it starts granting itself privileges, immunities, exempting itself from the law. And pretty soon what happens is the branches are bigger than the tree, and the tree starts to turn over, uproot, and our sovereignty gets inverted, and we end up with a government of the government for the government. And as you heard earlier here, in the jury case that Paul was talking about, the Attorney General, who's supposed to be the people's attorney, was prosecuting one of the people. And what you'll find out is the Attorney General so many times is actually government's attorney. So let me conclude. Ron's going to finish here, but there's much more I'd like to tell you about the doctrine of absolute judicial immunity. You need to know about it. You can go to the South Dakota website. It's southdakota.judicialaccountability.com. That's one word. And there's an essay on there that talks about it. And what you also need to know is, Bill had mentioned it just before me, that our opposition is going fast forward against us. And our opposition is the state legislature. They've taken their public positions, their public office, both the House and the Senate, and public funds, and passed a unanimous resolution against our amendment. And we've written them a letter requesting that they reconsider that and withdraw it and issue a public apology, because they have violated the South Dakota Constitution by interfering in an initiative election. Because an initiative is very important. It's a direct vote. And so the legislature steps down a notch. They have to take off their legislative hat and they just become a regular citizen. And they get to vote on it, one vote, just like the rest of us. But they came out with their resolution urging voters to reject our initiative, to vote against it. And if they continue, if they don't follow through and withdraw that, we intend to go to court. That's the last thing we want to do. But we're going to seek an injunction against them because, again, they're using their office and public funds against the people. So thank you.
There's a lot we could say about this jail amendment in South Dakota and like. I just want to inform you, so those of you who are in the area or who are going to be around here on Monday, we're going to have a full day. In fact, you'll see Paymon. He'll instruct you as to the room to which we're going to have testimonies, and we will expound in depth about what we're doing there. It's really a glorious thing. In fact, I think for the first time we have the government on the run. Instead of being defensive, we've gone on the offensive, and believe me, they're very, very concerned. I'm going to give you some, hopefully I have enough time here to just give you some hints. First off, I hold in my hand a writing by the California legislature, legislative analyst Elizabeth G. Hill, and she's writing to our current state attorney general, Dan Lockyer. And it's interesting when I read this. This is not written by patriots or by people who we might consider love our Constitution or our country. But I just want to give you a few lines here to show you how concerned and serious they're taking this. Special grand juries. The measure creates 3 special grand juries, each of which would have statewide jurisdiction. Limitations on judicial immunity. Current law provides that judges are completely immune from civil claims based on actions taken within the scope of their judicial performance. As a result, perceived abuses by a judge within the scope of his or her judicial performance can only be remedied by appealing to the action in question to obtain a reversal, filing a complaint with the Commission on Judicial Performance, or petitioning the legislature to impeach the judge. None of these remedies allow the complainant to seek civil damages. They go on to say, this measure would provide a mechanism for plaintiffs to overcome this immunity. It says here, judges would no longer be immune from civil liability in cases of which they intentionally violate due process of law, deliberately disregard material facts, block the lawful conclusion of a case, or deliberately violate the U.S. or state constitution. Now, folks, this is not me writing. This is not even a politician writing. This is the chief analyst for the legislature of the state of South Dakota writing to the Attorney General. You can't get much higher authority than that. The only one higher than that is the governor. Now, this the idea that we would be in control of such a power and have it in our hands to present before the people. So I'd like to have you attend our rally we're going to have on the 13th. There's no charge. You just come and attend with us, and we can even let you have participation in that. We have been getting unbelievable media attention. You know, most people spend about a third of their resources, businesses, on advertisement, right? Well, we follow a policy that there's no such thing as bad advertisement. Here's a photograph of me in front of the Van Nuys Court. This is the Recorder newspaper out of San Francisco. It gives talks about legal cases. They must have took about 50 photographs of me, and they chose that one. This one's called Attacking the Immune System. We're getting all day, starting at 9 o'clock. 9 o'clock on, you can come in and get your belly filled. You can ask all the questions you want. This is by the Chet Brokaw, who is the reporter for the Associated Press. Now these are their words speaking here. Let's see. To show you some ideas of what they're saying about us. It's in South Dakota. Senator Lee Schoenbach, Watertown, said, the proposed constitutional amendment is backed by the same kind of people who killed a U.S. Marshal in North Dakota years ago because they hate the American system of government. Hey folks, those of you who have known me, I've been around for like 30 years, and many of you know me personally, but that's the accusation. Senator Schoenbach said Ron Branson, the California man who started the judicial accountability movement, is mistaken in his belief that a grand jury should be the top power in government. Branson and other supporters of the ballot measure apparently want to destroy the American system of government, set up by Thomas Jefferson, John Adams, and the nation's other founders. Well, these are the people I quote prolifically in our writings. We go all over the country. People read what I say. It's almost like they're finding out what I believe in, and then they just counter it. Mr. Branson and his people from Hollywood do not like America. Schoenbach said in remarks directed toward Branson, we don't need your trash here. Can you imagine a whole legislature that is afraid of me? Moore, Senator Moore, Gary Moore, said he hopes the South Dakota voters say, tell them to go to hell. Opponents contend the current system works because it allows the court rulings to be overturned on appeal, a state disciplinary board can punish and remove, and voters can throw them out if they do not like them. Well, we got the state attorney general, or written to the state attorney general, says the system doesn't work for any remedy for, oh, here's one you'll like. Senator Kerry McKinney, Sturgis. It just scares me to death. This has these people in South Dakota all frightened. There are 105 legislators there. One of them has said, I'm not going to have any part in this, but the rest 104, they're saying words that are just outrageous. Senator Lee Schoenbach called the proponents a posse comitatus hate group or nut group during a speech in the Senate State Affairs Committee. Believe it or not, I had the Associated Press call me up and says, "Mr. Branson, did you know you have been declared to be a certified nut? Do you have any comments?" I said, "Well, I'm not going to comment on that." But I had things I did want to say. I was wanting to say, well, does that mean I'm going to get a certificate, a parchment paper with over the seal of the state of South Dakota that I could slip under glass and put on my wall that says I am a certified nut? Here's the press and Dakotan in South Dakota. Up until 2 weeks ago, I was absolutely certain I was not going to run again, Moore said, but these jailbirds had got me lathered up. I want Amendment E killed. Moore planned to center his energy more towards killing Amendment E than in campaigning for office. He's running for office, but his main campaign is, we got to kill this thing. And they're properly correct. They say that if this thing passes in South Dakota, it's going to affect state after state after state. Well, I have to say here, they are correct on that one. We're going after this country. And we topple the first domino, and guess what's going to happen? All the way down to the end. And we're going right in with that power and pressure into the floor of Congress, because we already have a federal jail bill to make federal judges throughout this country accountable. Senator Moore says this initiative is the most absurd proposal I have ever seen brought forward in our state's history. Jail is making history in this country. Guess what? We are getting all kinds of attention by media. We couldn't afford it. Time after time after time. Here, there's chief justices of 3 different states that are tuning in here. One of them happens to be the state of California. Ronald George. He says, California has an outstanding and impartial judiciary and doesn't need extremists telling us how to change a system that has served us so well and to substitute a highly politicized system for the impartial process that we enjoy. Well, the Chief Justice of the state of Missouri tuned in and says, "Yeah, we got them out here too." He says, "When I first heard about this, I thought it was a big joke." He said, "But they're proliferating everywhere." And he said, "We got to be concerned it's going to topple our system." And then the state Chief Justice, a female, of the state of Kansas said the other two, "You need to be careful of your comments you're making, because these things may come before you and you've got to rule on them." Of course, they would be disqualified because they're saying things that they're against us in the media. So we've got the attention of this whole nation, folks. They're watching what's going on in South Dakota, and we're going to do it to them. We're going to do it to them hard. So if you got time Monday, please come. We'll answer your questions, and we'll even let you have some participation if we feel something you had to add to the conversation. I thank you for the time that we had, and God bless you.
Thank you, Ron. And I want to thank Ron for being such a dedicated and committed hard worker, because it's been many, many years of hard work by Ron Branson, Gary Zerman, and other jail activists, and Bill Stegmaier to bring this thing to the stage that it is right now. So don't think, folks, that grassroots activism does not work. It does, and Ron Branson is just a live example of that. Folks, before we take a lunch break, I want to ask you that because we're running late on the program, we're going to come back from lunch instead of 1:40 at 1:50. We're going to have the vendors go tomorrow rather than today. But about the luncheon, again, the hotel has its own luncheon you can have for $15 without a speaker, or the Ryan Fowler is going to be speaking at the luncheon, another one at the bar. I asked him to come up, give you guys a 2-minute overview for those of you who might be interested, because a lot of you asked about Ryan. Come on up, Ryan.
Thanks, Paimon. Today, during the banquet, I'm going to be talking about asset protection. And at this point, I have had several hundred clients under my belt. I'm going to share some of the good experiences and bad experiences of what people have done to get themselves in trouble and what people have done that has worked when their program was actually challenged. I'm going to tell a couple stories about real life scenarios where people were able to defend themselves from a frivolous lawsuit from the IRS. So it'll be good because after you leave this seminar today, the lunch banquet, you're going to have a real good idea based on actual real life experiences, what works, what doesn't, and why. So I hope you all come out to the banquet today at lunch. No, tomorrow I'm probably going to be discussing, it's going to be a continuation, and I'm going to hit some more advanced technical topics tomorrow. So today is kind of an introduction, an overview of what works, what doesn't, and why. Tomorrow we'll go more specifically into the precise things you should do to protect yourself in certain circumstances. Thanks, Anna.
Thank you, Ryan. And if you're interested in that, again, the lunches with Ryan Fowler, get the tickets at the front desk right here.